Good morning, everybody. It's Stephen Williams, founder and president of the CreditRepairShop.com. Let me grab my glasses real quick. I want to make sure I don't make any mistakes reading this stuff. There was a time I didn't even need glasses. Like the older I got, probably when I turned 49 years old a couple of years ago is when I started to need glasses for reading. I guess it's just something that happened. Today, we're going to be talking about court summons. I'm getting a ton of emails. I'm getting a ton of comments. People are asking questions about how to respond to them the right way. There's some misconceptions because the way that they structure a summons, it confuses people because you think that they're making statements, but they're actually allegations or questions about the debt that you owe. Before we get started, I got a whole new list of debts, debt collections. Let's just roll through them. I'm gonna mention the charge-off date and the amounts. We have all of these are mixed credit cards or payday loans. So we got mixed credit cards, $10.7 million being released. Charge-off date 07, past statute of limitations. You can watch any of my other videos that'll tell you how to do that. If you haven't subscribed to my channel, please subscribe to my channel. It's going to be different this time for you. If you have credit and debt problems, you're going to get them resolved so you can start watching other types of videos about having fun and stuff. It's going to be different when you come to my channel because we put stuff into action. We got more mixed credit card, $85.9 million, $85.9 million in bad credit cards. Charge-off date 07, past statute of limitations. Another mixed one, $1.2 million, charge-off date 2011. Another one, $1,073,000, charge-off date 2012. We got $8.3 million, charge-off date 2011. $7.8 million, charge-off date 2009. $28.9 million, charge-off date 2008. $8.9 million, charge-off date 2008. $21.5 million, charge-off date 2010. Payday loans, $1.1 million and $1.12 million. Charge-off date 2014. That's close for some states on the statute of limitations. We got $67.6 million 2008 charge-off, $62.2 million charge-off date 2008, $58.5 million 2008, $4.5 million 2012, $3.3 million 2012, $59.7 million charge-off date 2007, and $20 million charge-off date 2006. That's 13 years ago, and $12.1 million 2010. So you've seen in my other videos what they're going to do. They're going to get these collections. They're going to send out the 30-day letter, which is what starts the whole process for people ending up having a collection or having a summons, which we're about to go over. If you don't respond to these the right way or within the time frame, you're giving them permission to take the next steps. So step number one, they got the debt. They're going to buy it. Pennies on the dollar. Some of them are less than penny. I've seen some for .002. That's like you breaking a penny into pieces. That's how much they're paying for this debt. So they're willing to take the risk on the people that don't know the laws, that don't know about the statute of limitations. They'll get you to pay a small payment, even if it's $10, and you reauthorize the debt for a whole nother 7 years when you wouldn't have had to pay it at all. So pay attention to what I tell you on this channel. So the next thing that they're going to do, they're going to sell it. Debt collectors are going to buy it because it's like a quarter of a penny on a dollar for millions of dollars worth of debt. It's like going to the slot machine and you got a whole row, millions of dollars that you can get for pennies that you're putting in. So they're going to buy this and take chances on it. They're going to send out the letter, 30-day letter, that's going to request to pay the debt. If you don't respond to that letter, you're giving them permission to go to the next step. If you don't respond, you are responding legally, which means that you might owe this debt and you're running from it. If you owe the debt, you remember it from a long time ago, the next step that you should always do is go to your credit reports. If you don't have your credit reports, don't go to this free credit report stuff. You need to go and get one from the service that I'm recommending. Click the link below or go to your3scores.com because it's very important. You go there, you get those reports, and you see when the original charge-off date was. If it was charged off, and then you go to my website, thecreditrepairshop.com, or look it up online, the statute of limitations for contract law in your state. You look at that, you look at the reports on the original charge-off date, and then if it's past the statute of limitations for your state, and you haven't messed up and made a payment or something to the debt collection company, then all you have to do is write a simple letter saying, according to the laws of your state, that this debt that they're trying to come after you for, that you're trying to collect, is not valid due to the statute of limitation laws in my state. And if you continue, I demand that you cease collection activities, and if you don't, I'm going to report you to the proper authorities in my state, which is the state attorney general, or you might have a Department of Financial Institution. Reason why that's important is because every debt collector has to have a license. Every lawyer that's a debt collector has to have a license to collect debt. And they register it with them, and that's because if they break rules, you're able to report them, and they can take their license away from being able to collect debt. That is when you get their antennas up, when you put that type of wording in there, because they know that they're not screwing around with, that they're messing around with the wrong person. And these are just simple letters. You don't need to be try to write it like an attorney. Be straight forward with them. It works all the time. If it's not past statute of limitations, that's where you're going to probably get something like this, especially with these debts. The average accounts on some of those are $5,000, $3,000, $1,700, $2,000. They can garnish those wages, and that's why they're going to end up trying to go this route. If you do respond or you don't respond, if it's a valid debt, you may find yourself in a situation with them doing a court summons. When they do the court summons, this is what's going to happen. They're going to come to your house, or, usually they come to your house and they're going to serve you. Sometimes the sheriff does it. Sometimes it's just a company a processor that just goes out and serves people. In the old days, years ago, you had to sign for it. Now, because a lot of people were running, they didn't answer the door, whatever, you can legally be served if they just drop it at your door. Sometimes, in some states, if they just mail it to you, you could be properly served. It just depends on your state. Laws are different in every state. But you do not have to sign. Also, other people can sign for it. If you have it going to a P.O. box or something, someone there can sign for it, because they just got to prove that they serviced you at the last known address that they have. That's the proof. The laws are in their favor once it gets into this. Now, let's talk about what's on this summons, because it's very confusing to people. We have our summons here. In this corner is going to be the plaintiff. I'll put a P for the plaintiff, and defendant, you. And they're going to have it that way, and that's so they can identify who is suing you. This is where you got to be very careful, because you could get this thing thrown out of court if this is stated improperly, because debt collection companies and attorneys that do debt collection, they lie right here. A lot of them lie right here. And you won't know it unless you get your credit reports. This is something that happened with a client recently. Right here, they had the credit card company suing him, the individual, but when we looked on the credit reports, it stated that they had sold the debt to the debt collector. So, best case scenario, you just write to the judge responses to the debt collection, and you have to also do the other answers, which I'm going to go through real quick. But you would have ammunition, legal information to tell the judge that this summons is improper, that they lied on this summons because they did not disclose that they purchased the debt. They made it like the original creditor was coming after that person for the debt. They cannot do that. They get away with it because people don't know it. They just remember, oh yeah, I did have that debt. But the details is going to be in the questions, and that's where you'll be able to fight back. So we have the plaintiff who is suing you. We had a defendant, which is you. In this corner, we're going to have the case number up here, and we're going to have the date. That's very important because if you don't respond by those dates, which is going to be identified in here, they could get set it up to get a judgment against you simply because you didn't respond in the appropriate way. So now the next thing is it's going to be the actual complaint. And it could be either a demand or anything. They're going to put it in there, and they're going to say exactly what this summons is all about. And then they'll have these numbers. It could be different in your area. In my area, they'll put numbers, and they'll have these statements. In those statements, usually the first one, and I'll look at this one here. In this one, and it's different. There's no guideline on what question they have to put first. But on this one, they stated that the plaintiff is a credit card company, and they identified where they're from. They put that on there. So what you do is you just say, I don't dispute that. So plaintiff is a FDIC insured Delaware State Bank. That's what they put on that line. That's what really confuses people on how to respond, because it's like, okay, they are. So what you should do is you do your numbers. So you have your numbers of their statements with your questions, and you just say, like for this one here, plaintiff is a FDIC insured Delaware State Bank. You just put, I don't dispute. You're answering that. That's what they want. You answer that question. The next thing is, on here they said that this is an action for damages that does not exceed $15,000 exclusive of court cost, exclusive of interest. They kind of made some mistakes on here. Interest and court costs. So they're making this statement, and you just say, I don't dispute. Now, what they did here, so they lined this up here with these two, and then they went down and they said the breach of contract. This is where you're going to get into your disputing process. Now, we all know that if you have a debt with this company, you can't just be like you're going to outright lie and say, I didn't never have it with them. Now, if with the debt collector buying the debt and they list it with the company, this is where you would put that information about that, no, I do not have it with the company because it was sold to someone else. That's when you would start to put those answers in there. So we have here that this is an account based on the credit card agreement entered by the defendant, and you're going to say you don't dispute. Now it says here, defendant used or authorized the use of the account and incurred charges and all of that stuff. Like they're saying that the things that was used on it. And then next, and you just say, I don't dispute. Like these things you can't really dispute because these are things that they can easily prove that happen. But there's a spot that you will be able to start your fighting process, and all they're doing is they're just like when you're selling people stuff, you want to get people to say yes to a lot of things. Well, this stuff here is actually what they're doing is they're getting you to say yes. Yeah, that's true, that's true, that's true. They're setting it up for the judge also. So now the next thing that they did is they put a statement, which how are you going to dispute a statement that they give to the judge that has your information and all that stuff on it? So you got to say I don't dispute. That's the statement. Just slow down if you're getting ahead of me. Slow down because we haven't got to the part about where you're going to dispute. Now, the next thing is where they said a defendant owes, and on here it was $8,000. This is where you start to do all of your work. If number one that they had sold the debt, you would not even have to have went through all of this. You would just say simply to the judge that you never did business with that company and you want them to prove that you owe them money, because on your credit reports, and you would attach a copy of where it stated that it was sold, you would tell them that that debt was sold, that this plaintiff that they have listed here is not the actual company that or plaintiff that is suing you for the money. Best case scenario, they just throw it out. Debt collector says, screw this person. We're not going to mess with them. They know the laws. Worst case scenario, they'll refile it with the debt collection. Debt collector will refile it and they will put themselves as the plaintiff, and then they will redo their summons, send it back out. But this is where you would start fighting them again, is that in the spot where it said defendant owes plaintiff and he's got $8,100 here, this is where you make them, regardless if it's the original creditor or the debt collector, this is the door that opens for you, is that you make them prove everything. So you want your original contract, and someone that wrote me a comment, and they said that they had asked for the original contract with a debt collection company, and they kept disregarding it when it was in the original phase before summons. And I said, what you want to do is you want to make the request again to the debt collector, send it certified mail, because right here at this point, that's going to work on your side, because you're going to say that I've been requesting documents from them and they just been disregarding, and here's my proof that they received it, just like they did the summons, and their proof that you potentially received the summons. And also in some states, it's different for every state. Some states do require that you personally sign for the summons, and you can actually get a summons thrown out of court if you don't have proper service. A lot of that is still going to depend on the judge. So you want the original contract, you want the balances, all the balances, you want all of the payments that you made, the credits, the charges, with your signature on them. So if they said that you went to Macy's, you want to get a statement showing that you signed for what was purchased at Macy's. You have a right to do that. They must maintain that. They are a business, and these are records that businesses, especially when you're doing credit card transactions, you must maintain all of that information. They make the business owners, I'm a business owner that takes credit card payments, and they make us maintain that. They request those documents. If someone disputes it, you're actually saying, well, I'm not sure about this balance. You're not saying that the balance isn't yours, so you're not putting yourself in a bad situation. What you're saying is, I want them to give me everything to prove that this is, number one, the right card, show me my signature, give me the balances, give me the payments that I've made, the credits on those, the charges with my signature, and another thing is that your interest rate and payoff disclosures. You want to make sure that they followed the new laws that were enacted back in, I believe, 04, not 04, '08 or '09, somewhere around that time, or 2010, where they had to disclose on everything, your interest rate and your payoff, because people were saying they'd never be able to pay off their credit card. So it's required that they put that on the statement. If that's not on the statement, they just broke the law. You get this whole thing thrown out. So now you put those in, and you make those requests. Anything else that you can think of, think outside of the box. This is the way that I learned to do this. You think outside of the box, and it starts to at least give you some argument positions that you can have. Usually also they'll attach a document on this one. They attach just one bill. That's all they did. And they did attach that their legal department was trying to contact them about the debt. They had put that on there also. So these are some things that they could attach to their questions here that they have. And then they'll sign to it here we go. So now, and then towards the end, what they'll do is they'll tell you how many days you have to get the complaint back over to them. It's going to tell you the attorney who's usually handling it. So you need to get that information over to them. Hold on one second. Got employees coming in now. So you're going to have the attorney. It's going to have the judge. It's going to show that they sign off on all of this. And you need to get this information over to them, to both. One copy to them, one copy to the judge. One copy to the plaintiff, one copy to the judge, which is going to usually be the plaintiff attorney in the time frame that they have on the court summons. Let's see here, just to make sure. And then they might make some statements on here about, if you're visually impaired or have any disabilities, different options for you. Now, let's talk about some quick ways to make this stuff go away. Quick ways to make this go away, because I've had a lot of people that fell into this category. One of the quickest ways to make a credit card company go away is if you have if you're on disability, limited income, something, a true hardship, when you contact the debt collection company, and you notify them of that, if it's a debt that they have been assigned to collect from the original creditor, I would say 9 times out of 10, they're going to choose not to come after you for the money if they are being hired by the original creditor. I'm not saying that if they purchase a debt, they're going to try to go after you in all different ways if they purchase a debt. But if you notify them of your hardship, notify them that you're on disability, notify them that you're on limited income, they will usually stop the process, or they may try to go ahead and just get a default judgment, but there's nothing that they can really do about it. So I hope that this was very informative to you. Please subscribe to my YouTube channel. It's going to be different than it ever was before for you. You're not going to be worried about this. You're going to be moving forward in your life. If you need help, go to my website, thecreditrepairshop.com. If you need your reports and scores, go to the website link below, www.your3scores.com. Post your comments, ask your questions. There's no stupid questions. Like the video. I really appreciate it. Share it with your friends and family. This is real deal stuff. So again, and then also have a happy Thanksgiving. Today is Wednesday, right before Thanksgiving. Hope you and your family have a happy Thanksgiving. Enjoy the holidays and get some rest, and start thinking about how you're going to start improving your life starting today. Don't worry. Don't wait until the first of the year for some New Year's resolution. You need to have a resolution every day of your life. Thanks a lot.